Breaking news, we want to transition and get you to Florida because Wade Wilson, the sentencing, a jury has to decide death or life in prison. We understand there's a verdict in the sentencing phase. Here's a live look at that courtroom when they are all...
Again, the state defense defendant present. Is either side going to want the jury polled?
I don't know. Yeah, I believe that's reflected in the...
If it is, I have the polling question. That's the standard question as part of death penalty cases promulgated by the Supreme Court. That's so I can use that.
Yes, yes, please.
Okay.
All right, there he is. You see the defendant. He's already been convicted for the murders of two victims, Melton and Ruiz. Both of these victims suffering horrible deaths, and he has just been seated with that same expression on his face throughout the guilty phase. Once he was found guilty in Florida, a jury has to determine whether or not he will be sentenced to death. They have to consider mitigating factors, aggravating factors, as well as only 8. This is not a unanimous decision for death. They only need 8 of the jurors to determine that it will be a decision for death. I believe. I'm going to confirm that now. And that is correct. So we are waiting for the jury to come in for him to learn his sentence. Let's bring in our guest, knowing I may have to cut you off, but we have psychiatrist, forensics expert, and body language analyst Yalda Safai and Deputy Public Defender Philip Dubé.
All right, please be seated.
Shoot, stay with us. Let's go back in.
Ladies and gentlemen of the jury, I've been informed that you have reached a verdict or a decision in this matter. Is that correct? Who has the verdict form? All right. You'll pass that to the bailiff. All right, verdict form appears to be in order. We'll let the clerk publish the verdict.
In the Circuit Court of the 20th Judicial Circuit in Forley County, Florida, criminal action, State of Florida versus Wade Wilson, case number 19 CF 568. Jury verdict form, penalty phase. We, the jury, finds as follows as to the defendant, Wade Wilson, in this case. As to count 1, first-degree murder, Kristine Melton. We, the jury, unanimously find that this state has established beyond a reasonable doubt that Wade Wilson was previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation. Yes. We, the jury, find unanimously that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of another capital felony or of a felony involving the use of threat of violence to the person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification? No. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. If you, the jury, answered yes to any aggravating factor listed, proceed to section B. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. We, the jury, unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Wade Wilson should be sentenced to life in prison without the possibility of parole or death. We, the jury, find by a vote of 9-3 that Wade Wilson should be sentenced to death. As to count 4, first-degree murder, Diane Ruiz, we, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of aggravating factors. We, the jury, unanimously find that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of another capital felony or of a felony involving the use of threat of violence to the person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. We, the jury, unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Wade Wilson should be sentenced to life in prison without the possibility of parole or death. We, the jury, find by a vote of 10-2 that Wade Wilson should be sentenced to death. Dated this 25th day of June 2024 in Lee County, Florida, 4-person, 234.
Does anybody want the jurors to be polled?
Yes, please.
Okay. Members of the jury, we're going to ask each of you about the jury's decisions that you have just heard. And I'm going to go juror by number. So juror, do you, juror 97, agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror 97.
I'm sorry.
Okay. Do you agree that the decisions read by the clerk accurately reflect what the jury decided?
Yes.
Juror 234. Do you agree that decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Juror number 3. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror 205. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes.
Juror 101. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes.
Juror 215. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Juror 87. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes.
Juror 362. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, sir.
Juror 136. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, sir.
Juror 193. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, sir.
Juror 315. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes.
Juror 309. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We've recognized...
All right, the judge is thanking the jury. We're going to leave it here so we can watch as he continues to do that. We'll jump back in if anything new is happening in that courtroom. In the meantime, I mentioned and now do want to bring in our two guests. We have Yalda joining us, as well as Philip Dubé, Yalda Safai and Philip Dubé. Let me bring you back in now. I have to ask you first, Yalda, you've got lots of experience and expertise, but I want to focus on that body language piece. He just heard delivered by this jury a death sentence. He will be put to death under the sentence of this jury, and yet he's right there. He just looks so stoic to me. Tell me your thoughts.
Sure. I mean, I obviously don't know him. I don't know what's going through his brain, but to all of us, it kind of appears like he's pretty nonchalant, right? He just got really bad news, and he has complete poker face on. Let me tell you something, though. A lot of times when someone is anticipating some sort of news and they've been in limbo for a while, waiting for good or bad news, when they finally get that news, no matter what that news is, even if it is bad news, sometimes they're just relieved. So this could be what we're seeing right now, could be just him being relieved that he finally got bad news. To all of us, it looks like very nonchalant, doesn't seem to care that he was just given a death sentence, but people react differently to bad news. So I don't think we should jump and judge him based on his facial expressions right now, because we all react different. Yeah.
And I apologize. I didn't mean to interrupt you. I did want to note how he was seated there at the end. It's just interesting. Now he even looks kicked back and relaxed. His facial expression, in my opinion, didn't change throughout the course of the trial for the conviction or the sentencing phase, even listening as death sentence was delivered. Philip Dubé, as a deputy public defender, we know a defense is a win if they save their client from the death sentence. And in this case, that didn't happen. What must this be like?
Well, I'll tell you what it's like. I think the defense is kicking its heels. And the reason why is that it was not a unanimous verdict for the penalty phase. You can bet this is going to be litigated all the way up to the U.S. Supreme Court. I don't believe that Florida can unilaterally dilute the verdict process by saying that you can sentence someone to death if 8 out of 12 are willing to do that. It is less than the civil standard, Ashley. In the state of Florida, you need 6 jurors in a civil matter to reach a civil monetary verdict. Can you believe that? It has to be unanimous. But in a death case, as long as you have been convicted in the guilt phase, if only 8 feel you should get death, you can bet this is going to be litigated all the way up. And as to the first victim, they had a 9-3 for death. And as to the second victim, they had 10-2. The reason why this is significant is that, remember, the holdouts, those minority jurors, have what I call a protected individual representativeness. And when you bypass the will of minority juries, it tears the spirit out of participating in a criminal death case. Why on earth do they even bother impaneling 12 if the voices of the minorities are inconsequential? I have a real problem with it. The other thing is, too, historically, these type of verdicts have a disproportionate impact on minorities. And when I say minority, I don't mean people who are just black or brown. I'm talking about people who are a minority in society, such as gang members. And he is clearly a tatted out gangster.
All right, there he goes. We're watching him now leave the courtroom. And I just want to mention, Philip, you raised a great point because the defense already raised that it was requesting this judge to require a unanimous sentence of death. And the law in Georgia's been, in Florida rather, has been changed. But the timing of this meant that the judge denied that and said, no, it's majority 8 out of 12 can sentence death. But to your point, I am absolutely sure you are correct that that is going to be a legal argument made on up to the Supreme Court. We'll see what happens with that. Both of you, if you would stand by, we need to take a break. I want everyone to know the judge did just set the sentencing Spencer hearing. That's July 23rd at 9 a.m.